5 देख लिया था, 26 में एंट्री ले ली थी। 26 में अपन ने 25 देखा था, एक बार क्विक रिवीजन कर लेते हैं। बेसिकली आर्टिकल 25, आर्टिकल 25, हाँ, आर्टिकल 25 और 26 basically both talks about right to religion for the individual purpose. So basically article 25, 26 and 27, 28. So 25, 26 right to religion for individual perspective, right to religion for individual and community level. And article 26, 27 and 28 basically 27 talks about no tax for promotion of religious institution or any religion. And article 28 talks about in certain educational institution, basically who are the institutions who are government funded or partially government funded, or any type of share which is funded by the state government or the union government, or institution who got the function totally given by the legislature of the union or the state, should have some restriction. So basically it called in certain educational institution restriction of restriction of religious worship and instruction. So that is the basically article 25, 28, which talks about right to religion. Now discuss one by one in detail because I have already discussed 25. Let me discuss once it again. So what's the article 25 talks about? Now let us discuss about 25. First discuss about 25. It basically talks about right to religion for individual perspective. Basically right to religion to individual. What do we mean by individual? Basically, every person or every citizen, or it may be a foreigner, it may not be a foreigner, it may be citizen, it may not be citizen. Every person have the right to follow any type of religion, to believe on any religion on their personal choice. There is no any specific restriction on any individual to follow such relation, to follow such belief, to follow such instructions, to follow such community. No, every individual have individual right. They can do, they can follow, they can pray, they can preach, they can communicate, they can even spread, they can do whatever they want with respect to any religion. So basically, all person have right to follow any religion, to practice any religion, freedom of to profess, freedom to profess or spread or preach or influence to any religion. It also includes basically carrying Kirpan by Sikh community. So these are the rights which has been given to individual perspective. They can believe on their own perspective. They can practice any type of religion. They can practice their freedom to propagate, to practice, to spread, to preach, to pray, whatever in whatever they want. They can also have the in this article inherently it also includes that carrying Kripan by Sikh community is also a part of right to religion from individual perspective. But these all right or not. Basically, if you are saying that propagate, then it also includes to जैसे नहीं जुलूस निकालते हैं मुस्लिम कम्युनिटी जुलूस निकालती है. तो for this, it's also include under Article 25 of the Constitution of India. Now, again, this rights is not absolute. So, not absolute. Therefore, they can be restricted. They can be restricted on ground of public order, health, morality, etc. So, Article 25 is not a absolute right. Therefore, they can be restricted on the ground which has been mentioned under Article 25. The ground are supposed to be public order, health, morality, and etc. These are the grounds on which Article 25 can be restricted. What is the Article 25? Basically, Article 25 gives the power to follow any type of religions, to practice any religions, freedom to pray, freedom to praise, freedom to follow, freedom to practice, uh, freedom to propagate, freedom to convince other, and also they have also freedom to perform any ceremony activity. They can also have to perform any type of ritual activity. So they have all the rights under mentioned in Article 25 of the Constitution to the individual level. Now, let's again these rights are not absolute in nature, therefore they can be restricted on the ground of Article 20 on the ground of public order, health, morality, etc. Now, I have said that if you are saying that it can propagate, it can convince to the others for their religious promotion. So, what about anti-conversion law? So, if you are saying that it is anti-conversion is a valid point, so what about anti-conversion? So, recently in the MP government made a law that fraud or coercion anti-conversion is is offense offense. So basically, MP government made a law that conversion by fraud, conversion by coercion, conversion by one's conscience, uh, conversion by one's against one's conscience, one's belief, it will be an offense. So this matter has been goes to the Supreme Court. Then Supreme Court says this law is valid. So therefore, Supreme Court also stated if any conversion is by against one's belief or by illusion or by forcing someone or by fraud, these all type of conversion should be an offense and it will be an offense. So therefore, MP government after the law of the MP government, Supreme Court reiterated the judgment, reiterated the process of the MP government. So now it should apply to all across the India. So now this is the constitutionally validity of the Constitution of India. Now let's talk about Article 25 Clause 2 of the Constitution of India. Now let us talk about Article 25 Clause 2 of the Constitution of India. Let's read first, then we will discuss on it what the Article 25 Clause 2 says. Then after we will discuss Article 26 of the Constitution of India, which talks about right to religion for the cumulative perspective. So first read about Article 25 Clause 2. Article 25 Clause 2 basically the restriction, basically exception to Article 25 Clause 1. So what is the article exception? Basically it states that nothing in this article shall affect the operation of any existing law, prevent the state from making any law regulating or restricting any economic, financial, political, or secular activity which may be associated with the religious practice. So basically, it states that Article 25 Clause A, subclause A states that state can make law for economic, political, financial activity of religious institution. This is basically according to Article 25 Clause 2 subclause A, state can make a law for regulating the economic activity, financial activity, political activity, social activity. So state have the power to make on law. It under the Article 25 Clause 2 subclause A. Now let us read Article 25 Clause 2 subclause B once. Article 25 Clause 2 subclause B says that state can make a law for purpose of social welfare, reform, or for throwing open Hindu temple to the all section of Muslims. So basically, Article 25, Clause 2, Subclause B states that state can make law. State can make law for upliftment of upliftment of socially backed people by religion. So state can interfere, state can make law to uplift the for the social welfare and also therefore open Hindu society. So state can make law. Therefore, it states that even religious activity also regulated. That's have been discussed. Let's wait 1 minute. क्या लाओगे? दाल रोटी नहीं लेंगे नहीं लेंगे
घर को दे दे चापान आपका खाना बनता है कोयला पर
अरे बस बस बढ़िया ही तो है छोटू अपना मस्त आदमी बना लेता है तुरंत।
नहीं नहीं, कुछ नहीं होता, मैं कल देखा है ना। बात ठीक है।
बस। कौन सी दाल है भाई? मिक्स दाल। आगे करो थोड़ी। ना। ओके। Okay, now let us discuss about Article 25, Clause 2, Clause B we have discussed. So basically, for the upliftment of the socially backward, the state can make law under Article 25, Clause 2, Subclause B. And Article 25, Clause 2, Subclause A, it is the exceptions to Article 25, Clause 1. Therefore, a state can make law for the economic, political, and financial activity of the religious institution. Now, this is the argument of the Article 25 clause 2. Now let us read first Article 26 of the Constitution of India. What the Article 26 of the Constitution of India says. Article 26. Article 26 of the Constitution of India says that freedom to manage religious affairs subject to public order, morality, and health, and every religious denomination or any section thereof shall have the right to establish and maintain institutions for religious and charitable purpose, to manage its own affair in matter of religion, to own and acquire movable and immovable property, and to administer such property in accordance with law. So basically, it also gives the right to religion at community level. Under this article, every religious denomination, what do we mean by denomination? Basically, religion, religious institution, religion, and also it includes subgroup of religion, basically Buddhism, Jainism, Sikhism. So these are the subgroup of the religion. So this also includes subgroup of the religion. So every religious denomination shall have right to establish their own institution for religious purpose. Plus, they have also right to manage their religious institution. Plus, they have also right to acquire movable or immovable property. So these are the basically which has been mentioned under Article 26 of the Constitution of India. But again, this is not the absolute right. Therefore, restricted on ground public order, health, morality, etc. So basically, Article 26 of the Constitution of India says that subject to public order, basically it's not absolute right, so it can be restricted on the ground of public order, health, morality, etc. Every religious denomination or any section thereof shall have the right establish, they can establish their religion, they can maintain their religion institution, the religious institution for the charitable purpose, and they have also right to manage their own affair of their religious institution and religion. And they have also right to acquire movable and immovable property. And they have also authority to maintain these property. So basically, if you have heard that Waqf board of the Muslim community, the regulation of the Waqf board is come from the Article 26 of the Constitution of India. So because Article 26 gives the power to any religious community establish their own institution, to manage their institution or religion, and they have also right to acquire movable or immovable property. They have also right to manage the property which has been acquired by the movable or immovable. So these are the basic Article 26 of the Constitution of India. Now, therefore, we have discussed Article 26 of the Constitution of India. Now, in the case of Sirur Mutt case, so basically, because huge interruption by the state in the domain of religion, because because huge interruption by state in religion, a case has been gone to the Supreme Court named as Sirur Mutt case. So Supreme Court in the case of Sirur Mutt case. So court in this case, Supreme Court stated that every religion have their core part. Basically, in every religious community, they have their one core part through which religions moves on. So state cannot affect the core part of the religion. So basically, Supreme Court stated that state cannot interfere into core part of religion. Basically, this is the religion, and within the religion, the whole religion is depend on some principles. So these principles should not be affected by the state. So in the Sarur case, this has been stated by the court. Therefore, and Supreme Court also stated, what about the core criteria? Who will decide what is the core part of the religion? So Supreme Court said, मैं क्यों बैठा मैं हूं ना. Then Supreme Court also stated core part of religion will decided by Supreme Court. So this is the case in this case where Supreme Court stated essential religious practice should not be affected by the state. Who will decide this is the essential religious practice? Then Supreme Court said, I am the person. I will decide. Supreme Court will decide what is the core part of any religion. So therefore, in this article, if you have seen that restriction on firecrackers. एग्जाम्पल के तौर पर अगर हम बात करें तो restriction on firecrackers during Diwali, because firecrackers is not a core part of Diwali. Nothing, nowhere has been mentioned that on Diwali you have to burn firecrackers. So, Supreme Court stated that firecrackers are not a part of essential religious practice, so therefore it can be restricted by the state. So it is not ERM. It is not a essential religious practice ERP. और अगर अपने एग्जाम्पल की बात करें, सो प्रेइंग, जैसे नमाज अदा होती है मुस्लिम कम्युनिटी में, तो प्रेइंग इन द मॉस्क, इन द मॉस्क इज ERM। ये तो एसेंशियल रिलीजियस प्रैक्टिस हो सकती है कि भाई आप मॉस्क के अंदर प्रे करते हैं, इट इज फेयर इनफ, बट if you are praying outside the mosque, then it is not essential religious practice, because you are violating the other's fundamental right. You are capturing the public place. You have no authority, you have no right to do so. So praying in the mosque is valid, but praying outside the mosque is not essential religious practice. And one other example, if we can say that prohibition of women in Sabrimala case, in Sabrimala temple. So basically, what is the case? Basically, women who is the age of their menstruation age are restricted to enter in the sanctum sanctorum of the temple. So Supreme Court stated nowhere has been mentioned that women cannot enter into the sanctum sanctorum of the temple. So Supreme Court stated that it is not the essential religious practice. So therefore state can make law on it. So basically prohibition of women in Sabrimala temple is not a essential religious practice. So therefore state can make law, or state can make law for the upliftment, for the social purpose, for the social welfare of the woman perspective. So again, this is not essential religious practice. So in various cases, Supreme Court also triple talaq. How can we forget this? Triple talaq. Basically, Supreme Court also stated triple talaq is not a essential religious practice of the Muslim community. Nowhere has been mentioned in any book, in any guidebook, and any Quran that triple talaq is the mandatory for the Muslim community. No, and even no any single word has been mentioned about the triple talaq. So basically, triple talaq is not the essential religious practice, so therefore state can make law. Or hijab case, wearing hijab. So again, wearing hijab is not a essential religious practice of the Muslim community. It is the individual's choice. They can follow or they cannot follow. It totally depends on their choice. Who can use to say them you should wear the hijab? So wearing hijab is again not a essential religious practice of the Muslim community. Now this has been laid down by the Supreme Court guideline. Now So the various criticism has been made against the judgment because indirectly you are again affecting the religious institutions. So what is the criticism against the ERP? So now the current status is that. So state cannot make on the law which affect the essential religious practice. And what is the essential religious practice of any religion? It will be decided by the Supreme Court. So now ERP अगर अपन बात करें, ERP के अगेंस्ट में कुछ फेवर आर्ग्यूमेंट और फेवर में कुछ आर्गुमेंट लिख लेते हैं। अगेंस्ट में अगर बात बात करें कि भाई देखो ईआरपी को कौन डिसाइड करे कि भाई ये कोर रिलीजन की एक्टिविटी है कि नहीं, तो सुप्रीम कोर्ट। अब सुप्रीम कोर्ट के पास कोई रिलीजियस नॉलेज तो है नहीं, वो तो लॉ की नॉलेज रखते हैं। तो जब वो लॉ की नॉलेज रखते हैं, उनके पास ऐसी कोई रिलीजियस नॉलेज नहीं है, तो हाउ कैन दे डिफाइन? बिकॉज रिलीजन इज बेसिकली बिलीफ ऑन देयर इंडिविजुअल. So on the basis of law, how can you decide that it is the belief of any person or not? So basically, criticized because ERP will decided by Supreme Court, and Supreme Court is not of religious knowledge person. Basically, they are because they totally depend on law. No, again, because so this is the criticism. Now, if we talk about favor, because huge interference by the state, because huge interference by the state, therefore make restrictions by not affecting the core part of any religion. So these are the basically argument which can be said about the essential religious practice. Now we have discussed, now we have done about the Article 28, 26 of the Constitution of India. Let us move Article 27 of the Constitution. As we have discussed that 25 to 28 all are talks about the right to religion, and we have discussed about 25 where we give the right to the individual. Article 25 clause 1 says that individual have the right to profess, to confess, to follow, to preach, to publish, to whatever they can want to with respect to any religion. No one will force to do so. So these are the basically rights which is given to the to individual. But Article 25 clause 2 subclause A says that state can make law for the economic, political, and social activity of the religion or religious institution. And Article 25 clause 2 subclause B says that state can also make the law for the social welfare of the any person, for example triple talaq or whatever be the matter. Now Article 27 6 talks about Article 26 talks about right to religion for the community purpose. Basically every religious community have the right to establish their own institution. They can manage their institution, they can acquire the movable or immovable property, they can manage their property which has been acquired by the movable or immovable property. So these are the rights which has been given by the which has been given by the Constitution of India. Now we have also discussed about the essentially the aspects of the religion. Basically it states that uh, state cannot interfere in the core part of any religion. Basically, and who will decide the core part of the religion? Basically Supreme Court will decide the core part of the religion. For example की अगर अपन बात करें तो ट्रिपल तलाक, which is not the core part. Prohibition of women to entering in the temple, it is not the core part. Triple talaq is not the core part. Wearing hijab, it's not a core part. So this is the example. Now, if we say the criticism, so basically criticism is that Supreme Court will lay down what is the ERM practice or not. So Supreme Court is not a religious authority. They have no knowledge on the religious matter. So how can they decide on the belief of any community? Because it may be a possibility that many things are not written on the books. They followed by their mentality. So basically बहुत सी ऐसी चीजें होती हैं जो जनरेशन पे जनरेशन तो आ जाती हैं लेकिन वो बुक में नहीं रिटर्न होती हैं तो हाउ कैन दे decide the one's belief only on the rule, only on the guideline which is mentioned by in the law in the book. So that is the basically. But if we talk about the favor, so basically use interference by the state in the domain of religion. Therefore, restrictions should be made on the states. Therefore, they cannot affect the cultural or the religion negatively. Now let us talk about Article 27 of the Constitution of India. Then we will talk about Article 28 of the Constitution of India. Okay. Now let us read Article 27 of the Constitution of India. What the Article 27 talks about? Let's read first. Okay, we will discuss later. Just wait a minute.